For decades, the relationship between employers and employees in India was, well, complicated. It was governed by a web of laws, some nearly a century old. But that's all changing. Today, we're going to break down the Industrial Relations Code of 2020, a huge effort to create one single modern rulebook for the Indian workplace. Just let that sink in for a second. We had laws written before India was even an independent nation that were still supposed to apply to today's tech startups and gig economy. It created a system that a lot of people felt was just messy, outdated, and honestly really hard for anyone to navigate, whether you're a worker or an employer. So, at the heart of that old system were these three big laws: the Trade Unions Act from way back in 1926, the Industrial Employment Act of 46, and the Industrial Disputes Act from 47. Each one handled a different piece of the puzzle, which is what made it such a tangled system. The main goal of this new code? Take all three and roll them into one. All right, so here's our game plan. First, we'll look at why this change was even needed. Then we'll get into the new rulebook itself, what's in it for workers and unions, and then what's in it for businesses. And finally, we'll step back and look at the big picture, this delicate balancing act the new law is trying to pull off. The big idea behind this whole overhaul was, in a word, simplification. The argument was that this tangled mess of laws was making it harder to do business. It was slowing down how quickly disputes could be resolved, and it was just creating a ton of confusion. So the goal was to create a single, much clearer framework that could actually keep up with a modern economy. And this is the solution that was put on the table: the Industrial Relations Code 2020. The vision here is for this to be the one-stop shop, a single source of truth for everything from union negotiations to workplace rules and figuring out disputes. You really got to pay attention to the language here. Amalgamate, simplify, and subsume. That's basically its mission statement. And it tells you this isn't just a minor update. It's a fundamental rebuild of labor law, trying to get everything under one roof. And here's the really aspirational goal. See, the code isn't just pitched as a bunch of rules. It's framed as a tool to create a better, more collaborative relationship between management and labor. The whole point is to reduce friction and create what the law itself calls industrial peace and harmony. Okay, let's get into the nitty-gritty, starting with how all this affects employees and the unions that represent them, because the code brings in some major changes to how unions work and what rights workers have. So picture this. A company has a few different trade unions. Who actually gets to sit down at the negotiating table with the boss? The old system could be pretty fuzzy on this. The new code, though, gives a very clear mathematical answer. And that's the magic number, 51%. If one single union can prove that it has the support of a simple majority of workers on the company's payroll, bam, it becomes the sole negotiating union. The idea here is to stop the infighting between smaller unions and just have one clear voice for everyone, which in theory should streamline the whole process. The rules for calling a legal strike also got a major makeover, and some would say they've been made a bit tougher. Unions now have to give a 60-day advance notice. But here's the catch: the strike itself can only start 14 days after that notice is given. This basically creates a mandatory cooling-off period, giving both sides more time to talk and maybe, just maybe, avoid a shutdown altogether. Now, this is something completely new that the code brought in. It's a formal safety net called the Worker Reskilling Fund. The whole idea is to give a financial cushion and a path back to work for employees who've been let go. So how does it work? Well, for every single worker that's retrenched, the employer has to put an amount equal to 15 days of that worker's last salary into this fund. Then, that money gets sent directly to the worker's account within 45 days, giving them some resources to learn new skills and find their next job. Okay, let's flip the coin and look at this from the other side. The code also brings in some pretty big changes meant to give businesses more flexibility and make compliance easier. All part of that bigger push to improve the ease of doing business. A huge change that gives businesses way more flexibility is the formal recognition of fixed-term employment. This lets employers hire people on contract for a specific amount of time, like, say, for a 6-month project, without all the long-term commitments of a permanent hire. The goal is to let businesses react more quickly to what the market needs. But, and this is a really important but, the code also builds in protections. These fixed-term workers have to get the same wages and benefits as permanent employees doing similar jobs, just calculated for the time they work.
They even become eligible for a gratuity payment after just 1 year, which is a pretty significant protection. You can think of standing orders as the internal constitution for a company's workforce. They lay out all the official rules of the road. Under the new code, employers get 6 months to write these up. And, this is key, they have to do it by talking with the recognized trade unions. The code also gets really specific about definitions in tough situations. A layoff, for example, is now clearly defined as a situation where the employer just can't provide work because of things they can't control, like a power outage. And if that happens, the workers are legally entitled to 50% of their basic wages. Now, don't get that confused with retrenchment. It's different. Retrenchment is when someone's job is terminated for any other reason, like restructuring, or the position just isn't needed anymore. In that case, the code says the employer either has to give 3 months' notice or just pay them for that notice period. It's a pretty clear rule. So when you put all these different pieces together, the new rules for unions, more flexibility for employers, these new safety nets for workers, you start to see the bigger picture. The entire code is really an attempt to strike a very, very delicate balance. The slide really lays out that fundamental tension, doesn't it? On one side, you've got what employers want, easier rules and more flexibility. On the other side, you've got what workers need, job security and clear protections. The IR Code 2020 is trying to thread the needle right down the middle of these competing but equally important goals. In the end, it all comes back to this one line from the bill itself. Its mission is to be the single, comprehensive rulebook that covers the entire spectrum of the employer-employee relationship, from the day you're hired to the day you leave, and everything in between. And that leaves us with the ultimate question, right? The Industrial Relations Code of 2020 is incredibly ambitious. It's trying to serve two masters at the same time: business efficiency and worker welfare. The real test, of course, is going to be how it's all put into practice, and whether this new rulebook can actually achieve that delicate balance in the real world.